Hi everyone, welcome back to week 2 of my new HR and employment law weekly updates. Each week I'm going to be keeping you up to speed with everything that matters in the world of work. My name is Amy if you haven't seen me before, and in this week's episode we've got a packed agenda. First up, we're going to have a look at the Employment Rights Bill, what stage it's at in Parliament. Then we'll run through some upcoming changes to employment legislation, so you're ahead of the curve when it comes to policy updates and compliance. And finally, I'll recap on some of the most relevant and high-profile tribunal and court cases making waves right now, including rulings that can impact your day-to-day decisions at work. So whether you're in HR, legal, management, grab a tea, grab a coffee, let's get into this week's key updates. Okay, so first of all, an update on the Employment Rights Bill. The House of Commons passed the bill at third reading on division by 333 votes to 100. The bill has now moved to the House of Lords, where it's scheduled for debate on the 27th of March 2025. For more information on the different stages that a bill goes through, I've put a link in the description under number 1. Now let's talk about upcoming changes coming soon. If you watched last week, this is going to be a quick recap. Nothing has changed. We've got the Neonatal Care Leave and Pay Act coming in on the 6th of April 2025, providing eligible employees with babies requiring neonatal care the right to leave and pay. Employers will require a written policy. If you haven't got one, you can get this on my website, www.employmentwithamy.co.uk. I'll put the link at number 2. I'll also put a link to a video which explains the Act in detail and what employers need to consider now. I'll put that at number 3. Again, we've got the changes to statutory pay, national minimum wage increases, national insurance contribution changes. Check out my last video for those, or check out the description below and I'll put a written summary in the description. And I'll also put a link to my last video at number 4. So now let's get into the Employment Tribunal Court news. Firstly, a high-profile case. We've got the former chair of the Criminal Bar Association has officially been disbarred following a tribunal that found him guilty of sexual misconduct. So back in 2018, he invited a young woman in her 20s who was shadowing him during a mini pupillage to share his hotel bed. The tribunal found the invitation was clearly sexual in nature, said he abused his professional position and the trust she placed in him as a senior barrister. There was inappropriate touching, and the panel noted a major power imbalance. He was in his 50s, a senior silk, and she was just starting out in her legal career. Despite many people giving him glowing references and describing him as a mentor and a man of principle, the tribunal ruled that disbarment was the only suitable punishment. They said anything less would undermine public trust and send the wrong message about misconduct in the legal profession. The Bar Standards Board argued that this was serious misconduct and that he'd shown no remorse and lacked insight into his actions. And his lawyer argued that it was a one-off incident and pointed out that he's already faced personal and professional consequences. He's got 21 days to appeal the decision. I'll put a link at number 5. The next employment news comes under whether an employee can bring a claim anonymously at tribunal. So since 2017, employment decisions have been published online, meaning the names of those involved are typically shared. However, in certain circumstances, anonymity can still be granted, especially where there's a strong personal or professional reason. So there was a recent case involving a university lecturer, known only as F, who has Asperger's syndrome, brought a disability discrimination claim against his former employer. He asked to remain anonymous, arguing that if his condition became public, it could seriously damage his future job prospects. He even said he wouldn't continue with the case without anonymity. Initially, the Employment Tribunal rejected his request, but the Employment Appeal Tribunal overturned that decision, saying the original tribunal had set too high a bar. The EAT ruled that F didn't need to prove the stigma, just that his fears were reasonably held, which they found that they were. The EAT also noted that open justice doesn't always require revealing names, especially when the key facts of the case can still be understood without them. So yes, while tribunal decisions are usually public, anonymity is possible, especially where there's a real risk of harm and a good reason to protect someone's identity. I'll put the link to that one at number 6. Next, we've got a case that sparked a lot of conversation in the HR and employment law world, all about freedom of speech, workplace culture and gender-critical beliefs. Peter Wilkins, a former government scientist at the UK Top Secret Defence Science and Technology Laboratory, Porton Down, has just won a 2-year legal battle after he was forced out of his job. Why? Because he expressed gender-critical views. Wilkins had worked at DSTL for 15 years, including on high security defence projects and missions in Afghanistan. But when he shared his belief in biological sex, views that are legally protected in the UK, he was accused of being transphobic. Colleagues called him sad and pathetic and even suggested he was a security risk after he liked a post by the gender-critical charity Sex Matters. The atmosphere became hostile. Internal blogs were filled with posts attacking those with gender-critical beliefs. Wilkins reported the harassment to management, calmly pointing out that his views were protected under the Equality Act, but DSTL did nothing. An employment tribunal has now ruled in Wilkins' favour, stating that there was a clear, hostile animus towards gender-critical beliefs at DSTL. Senior officials, the tribunal said, were reluctant to challenge the pro-trans lobby within the organisation, especially a group called PRISM, which held significant internal influence. The judgment concluded that DSTL breached its duty to remain impartial and also found that Wilkins's freedom of speech had been unlawfully suppressed. Although the tribunal dismissed claims of victimisation, held DSTL accountable for harassment and discrimination, and now they're going to have to pay substantial damages. And finally, an employment tribunal has ruled that mixing up the names of non-white colleagues can amount to race discrimination. After an engineer at Jaguar Land Rover successfully made a claim against his employer, an Indian engineer was mistakenly called the name of another Indian colleague by his white co-worker, Magdalena Badescu, during a team meeting. The tribunal found that the two men had clearly different approaches and accents. The tribunal found that the two men had clearly different appearances and accents, and concluded the mistake was racially motivated, stating it's unlikely such treatment would happen to white colleagues. The panel highlighted that confusing people of the same ethnic background can make individuals feel lumped together and not treated as individuals, something that can reasonably be seen as unfavourable treatment. The employee also raised concerns about other incidents at work, including comments made by a senior manager about Indian IT staff, and felt that he was discouraged from pursuing a formal grievance for racial discrimination. The tribunal found that the company pressured him to withdraw his complaint and warned him that it could affect his future career, which the panel agreed was a form of unlawful victimisation. Some of the employee's claims were dismissed. The tribunal ruled in his favour on key points and criticised Jaguar Land Rover's failures to provide credible evidence, especially given that the other employees still worked there but did not testify. This case is a reminder that even a single incident involving racial assumptions can cross the line into discrimination, especially when the employer can't explain it in a non-discriminatory way. So that concludes our weekly update. I hope you enjoyed it. Don't forget to subscribe, hit the notification bell for when I post. I'll see you again next Tuesday, 4 p.m. Have a great week, everyone.